Hi everyone, this is Diane Manuel at Urban Wealth Management. Thank you for joining us for our monthly webinar, our Smart Women Savvy Money webinar. As you know, or many of you know, it's our opportunity to connect with all of our friends and clients and just everyone out there who we just are interested in a variety of different things, whether it's lifestyle or financial issues or, as you'll see today, some legal issues. It's a really great opportunity for us to connect with you all, get to see some of your questions, see what you're interested in. And for this particular webinar, we found that there's just a ton of interest talking about a successor trustee, what that is, and who that is. Before we get started, I just want to touch on some housekeeping things for us at Urban Wealth Management. First of all, I want to share with you that we have a new colleague, Miyu Ramirez. She is joined us just this week as a financial advisor. So I hope everyone gets to meet her, drop her an email, say hello, welcome her. She's great, and we're so happy to have another woman on our team. So please do reach out and drop her a note, and I'm sure you'll be seeing more of her and hearing more about her. Also, as always, I want to share with you some events. So Renee, who's going to be leaving tonight to go to New York because next week she is going to be at a luncheon, Investment News Women to Watch luncheon. So hopefully New York will get all cleaned up from all the snow and the wind. And on Tuesday, she's lucky enough to worked hard enough to receive this award. We're all super excited, and feel free to drop her congratulations also. While in New York, she will be doing her regular CNBC deal, but she'll be, I think she will actually be at the New York Stock Exchange. So she did that once before, and that's super exciting, and the CNBC people are super excited, of course, to have her there, and it's always fun to drop into the New York Stock Exchange to see, the cradle of capitalism here in the United States. Our next webinar is Mindful Goal Setting. It's with Imelda Villalobos. We had her on last year. We just got a great response from her, so we're going to, we brought her back, and she's going to really talk about how we can get our mindset in terms of goal setting about financial issues. And that is often the barrier that people have. So Imelda is going to help us in terms of activities and behaviors that we can do to get our mind in a better space. And then Renee, the queen of Social Security, she will be our May presenter. So we look forward to that, and I especially look forward to that because Social Security is a moving target, and we all can it's good to stay informed and learn about what's going on, what's changed, and how to make some of the best decisions for yourself and for your family. So it's just not always about you. And we have some blogs up. Our presenters today did a blog. Somita and Zakiya did a blog and talking about this is a perfect successor trustee. So please feel free to refer to that, especially if you want some more information after this presentation. And our blogs are always on our site. You're always free to go and search for them and pull them down. And so this will be a great reference point for today. And without further ado, I do want to introduce our presenters for today. Let's see, there we go. Somita and Zakiya, Norton Basu, Zakiya Norton, they can tell you a little bit about themselves, but they are absolutely wonderful partners through their law firm, Norton Basu, in terms of helping us and helping our clients stay straight in the estate planning space. They are just wonderful to work with. I've seen them in action, and I think you all are just going to really love this presentation by the two of them. So I'm turning it over to you all. Please feel free. Just go right ahead.
Thank you, Diane, for your warm and lovely introduction, and congratulations to Renee for her award. It is certainly well-deserved.
So this is Somita. I know we sound very similar sometimes on the phone, so you can just consider us one person with two very similar voices. So a little bit about who we are. We are the law firm of Norton Basu. We are the two founding partners. We met about 5 years ago, totally randomly, while volunteering at a legal aid society in San Jose, down up here in the Bay Area, and decided to kind of go out on our own and start our own firm. So we are very happy with our decision, and we are very focused on women and women's needs. It's something that we take a lot of pride in doing and reaching out to professional women across California. We have offices in Southern California, up here in the Bay Area, as well as in Las Vegas, and we are licensed to practice in both states. And a little bit about us personally: we are both single mothers. We have a large affinity for, me specifically, professional sports, and both of us, lots of wine is usually involved in our free time. And today we're going to be talking about successor trustees, and specifically some of the challenges in choosing the right one. It's very much a little bit more complicated than you would expect and not as easy as it seems. So we're going to walk you through what those steps are to make sure that you find the right person.
All right, so first of all, let's start with, who or what is actually a successor trustee. So you can think about it this way. When you decide to create a trust, you are the trustor, and that means the person that's created the trust, and you're also the trustee, and that just means the person that's managing everything that's within that trust. So you occupy both of those roles. You're wearing both hats. When you pass, then somebody else has to take over and put on the hat of managing what's happening with the trust and getting those distributions out. So that person is what we call a successor trustee. Now, that can be an actual person, or it can be a corporate trustee. And so that just depends on your personal circumstances and situation, which one might make sense. Either way, though, that person or entity is still going to be a fiduciary, and that just means that they have certain duties and obligations that they owe to you and to the trust, and they will be governed by California law.
Another thing to keep in mind here is that it doesn't have to be a person who's related to you. So people think they are hemmed in by their relatives or their children as successor trustees. If none of those people work for you, it can be a friend. It can be, somebody who is outside your circle of relatives. It doesn't have to be a relative.
That's true. And so what does the successor trustee do? So this is the person that's actually going to make sure that those wishes that you've outlined in your trust are carried out. They, again, have those fiduciary duties, so they are bound by law to carry those wishes out. So it's really neither here nor there whether they agree with, how you've laid things out or whether they would have done it differently. That doesn't matter. So in terms of what they actually have to do, they have to marshal all of your assets. So that just means kind of figure out what you have and where is it, get it all together, settle all your debts, take care of course, taxes, and arrange for sale of real property, managing that, and then, of course, the most important part is notifying those beneficiaries and making sure that the distributions go out to them as, laid out within your trust.
Yeah, and one of the things to note here is that the successor trustee does have to provide notification to heirs at law, and this term basically means your up to second-degree relatives who would have been entitled to inherit under probate law if you had died without any sort of a will or an estate plan. And under California law, even though those people are nowhere in your trust and you're not giving them anything, they have to be notified. So that's something that your successor trustee will have to do, and that's a legal requirement.
That's true. So now we'll talk about, what is it that you should be looking for in terms of picking this successor trustee. So we'll kind of go through ABCs to kind of make it pretty straightforward. So A is for availability. So they should be able, they should be willing, and they should be local-ish. And what we mean by able, we're not just physically able, but, mentally able. You need to have somebody in mind who is going to be able to tackle this responsibility because it is a big responsibility. And we've certainly seen in our practice where maybe you created your trust 20 years ago and you put your sister or your brother as your successor trustee, and back then that made sense. But fast forward 20 years and now maybe brother or sister, is physically not doing well, or maybe they now have dementia or something like that, and so now this doesn't really make sense. And so that's why it's really important to think of your document as living and breathing, and of course make amendments. And the other important thing is to pick backups to that initial successor trustee. So we're not just putting sister or brother, we're putting what is the next level down in case sister or brother can't do it. Who would that be? And so that's when it becomes important to think maybe a different generation, just so that you're kind of covering your bases.
Yeah, and we're pretty insistent with our clients who get, sometimes get a little irritated because we're like, you need a backup, and if the backup is of your same generation, you need another backup, because we have had instances where when the trust was created, the person picked their siblings. When the person passed, the siblings were in their 80s. Really not able to run around and do the things that needed to be done. And so luckily they had a backup who was the next generation down, and that person was able to fulfill the duties of successor trustee without us having to go to a third party. So it's always important to think about a backup. And the other thing that's really important to think about is when we draft our trust, we always include provisions that allow for a successor trustee to resign their role. And we put that language in there because even if they are able and willing, local-ish, and, they could do it, they really just don't want to. So they could actually voluntarily resign, and then it would go to the next person on the list.
Right. And the other thing to think about here is trying to determine between a family member or friend and a corporate trustee, and usually what makes that decision or the guiding principle would be how difficult and how complex are the terms of your trust. So if you have a situation where, for whatever reason, your trust needs to continue for like the entire lifetime of one of your beneficiaries, let's say a child that you just really need to make sure that they get distributions at very specific dates, you don't want lump sums, and you want it to go for a very, very long time, well, that's a situation where maybe now it makes sense to have an entity step in who can manage all of that and have those distributions go out, as and when they are supposed to, instead of having somebody try to remember and, figure all of those things out.
Right.
So B is for background. So as we say, this doesn't mean that your successor trustee has to be from the same background as you, but it does mean that we want to be thinking, do they have the maturity, do they possess the maturity to be able to manage something like this and deal with professionals. We want somebody that actually has, some level of financial literacy, financial 101. They don't need to be an expert, but they should have at least some idea about, some of these concepts that we're talking about.
Yeah, and, and we'll get into this in more detail in a little while, but, your successor trustee must be comfortable, if not familiar, but at least comfortable working with CPAs, financial advisors, and attorneys, because that's who they're going to need to engage in order to make sure that they comply with all of their duties under the law. So if they're really, they don't trust financial advisors, they don't trust accountants, they think they're shady, and they really don't trust attorneys, which, is the thing, then they're going to have a hard time fulfilling their duties as successor trustee.
That's right. And so C is for confidence. And so you need to find someone in whom you have confidence, and also that person needs to have confidence in their ability to, negotiate all the different moving parts, working with the attorney, working with the financial advisor, the CPA, and, of course, dealing with beneficiaries who, in some instances, have their hands out and their mouths open. So you need someone who can sort of withstand all of that, keep themselves above the fray, and really just follow the guidelines that you have within your trust.
Yeah, and where this really becomes an issue is when you have beneficiaries with competing priorities, and this is very common, especially when there's a house where one of the beneficiaries is living in the house, they don't want to sell it, they want to continue living there, and everybody else wants to sell the house. That's the most common scenario that we've seen, although we have seen variations of this in other instances, but that is by far and beyond the most common instance. And so in this case, the successor trustee, who may also be a beneficiary themselves, has to kind of really think about what's best for all of the beneficiaries and what is, in line with the wishes of the original trustor, the person who set up the trust.
Yeah, and this is a person, too, who's going to be dealing, not only directly with the lawyer, but also directly with the beneficiaries. So if it's somebody who maybe isn't on the greatest terms with, some of your family members, that is going to make this process more difficult than it otherwise would be. And on that same note, it really is important to find somebody who knows how to handle conflict. And so I think we all usually have a pretty good sense about the people in our lives and those who sort of run towards conflict, weapons blazing, and those who maybe try to take a level-headed approach and mediate and mitigate and look for a solution that's going to make everybody happy. So somebody who's really flexible in that regard would be a really good fit for this role.
Yeah, and you also need somebody who has none of what we call the ostrich syndrome. So they're not burying their heads in the sand and just ignoring all of the issues. We had a client once who basically did exactly that for 5 years. So after the trustor, who was the parent, passed away, the successor trustee literally did nothing for 5 years. And then, that kind of explodes into a lot of resentment and bad feelings amongst all the beneficiaries who were all siblings, and now you're in court because somebody's really upset that you haven't done what you needed to do. So being an ostrich is definitely not a good quality when it comes to being a successor trustee.
Yeah, that's true. That's a good point. That case was pretty sad because he really just put his head in the sand, and his siblings, rightfully so, finally had to sue him to get him to actually, perform his duties as successor trustee. And so, certainly that's not what any parent wants to have happen, just in terms of family relationships, and definitely not in terms of money. A lot of money had to go to a lot of different lawyers in order to finally resolve this and get the trust, the terms fulfilled. So that's certainly something to think about.
Just one other point on this particular issue. The successor trustee has to have confidence in what the trustor, or the settler of the trust, the person who created it, they have to have confidence in what was written down on the actual trust. Because in a lot of cases, we hear the successor trustee say, well, this is not really what my sister wanted. My sister meant whatever, X, Y, Z, but that's not what's written on the paper. So the successor trustee has to perform their duties based on what is actually written in the trust document. If your sister, mother, relative, friend wanted something else, it should have been or would have been written down as an amendment to the trust or in the trust itself. So the successor trustee has to go specifically with what's written down. Otherwise, it leads to these kinds of bad situations.
That's true. All right, that takes us to D, is for don't worry, there's help, which I'm sure everybody is glad to hear right about now. So your successor trustee is not going to be doing all of this alone, thankfully. It is standard practice for them to hire sort of a plethora of professionals to help them and advise them through this process of trust administration. So one, of course, would be, us, the attorneys, to help them, make sure that they're doing everything that the trust requires and, not violating their fiduciary duties. So they're following California probate law. Next, of course, would be CPAs. There are taxes that have to be filed on behalf of the individual who passed as well as the trust, and an accounting has to be performed. And that's what the CPA will do. Financial advisors are also going to be working with all of those accounts that are now going to be moved into accounts for the beneficiaries, as well as handling accounts that may not be within the trust, but like IRA accounts that may be rolling over to another individual. So they will be there to help and provide some guidance on what's the best way to do this, how should I take title to this, what should we do. So that's what their role will be. And then realtors, of course, because 9 times out of 10, there's a home that we, need to sell typically in order to be able to distribute that money to all of the beneficiaries. And so the good news about all of what we just said is that all of those fees do not come out of the successor trustee's pocket. They come out of the trust. And so, for instance, for us, we don't receive our fee up front. We receive our fee when all of the beneficiaries receive their distributions from the trust. So we don't get paid until they get paid. And so that helps take a burden off of the successor trustee's shoulders in that they have access to the money right away, and they are able to use that money to pay the CPAs, the realtors, and all of that, and they don't have to pay the big fees, until the end, until everything's been done and they're satisfied and the beneficiaries are satisfied.
Also, I think plethora of professionals should be a new trending hashtag.
Plethora of professionals is pretty great. Yes. Anything else on that?
No, I think that's about it.
All right, so E is for everyone asks this. So this is just a lot of common questions that we get, just about this specific topic, and so we thought we'd throw a few out and give our advice about what to do in those situations. So the first is, I don't want to upset my 2 children. Should I appoint them both as successor co-trustees?
Absolutely not. This is where we see a lot of conflict. The problem with having 2 successor trustees, 2 people serving together, is that everything has to be approved by both people who may have competing interests and or priorities. Also, it means that both people have to sign everything. And it also almost guarantees some level of conflict between those co-trustees. And we have seen this time and time and time again, where the settlor has passed away, their 2 children are co-successor trustees because mom and dad didn't want to upset the 2 kids, and the 2 children just cannot agree on what to do. And it devolves into litigation, basically.
Yeah, it's sort of based in irony because the reason that people make this decision is that they don't want one child to feel like, the other one was favored more, but it just ends up pitting these 2 people against each other just because most people approach the world differently. They have different values and opinions, even if they are siblings. And so the fact that the 2 of them have to come together for every single decision and sign everything together just really creates a lot of conflict. Typically, there was one child who was probably caretaker for mom and dad, and so they sort of feel like they have a better read on what mom or dad actually wanted to have happen after they were gone, whether or not that was in the document. And so now if they have to have their sibling who lived, 1,000 miles away, agree on what to do, they can kind of start to butt heads. And it's really disappointing because we know that's not what mom and dad would want in this situation. So we would say, focus on, the distributions and make those reflect, what you think is fair. But in terms of picking the person to manage all of this and make those decisions, it should just really be one person.
Yeah, it's a very potentially combustible combination of, moral indignation with stubbornness and lingering resentments among siblings or beneficiaries. So it's almost always a bad idea to have 2 co-trustees as successor trustees.
Agreed. So next question we get is, I really don't know anyone I can appoint. I don't have friends or family who really fit the bill for this. Can I appoint my lawyer as my successor trustee? And we have been asked this numerous times. We've been asked to be our clients' successors trustees, and our answer is always no, just because it's kind of a complicated situation. We have to help the successor trustee, usually manage the trust and manage the beneficiaries, and now we have to also take over the role of doing all of those things ourselves. And I think the biggest reason that we say no, while technically it is allowed, is there should be some checks and balances in situations like this. And when you give the lawyer, that much power over what's happening, I just think you've removed some of the checks and balances. And we don't know, the family members. We don't know the beneficiaries. And so that kind of puts them in an awkward position and us as well. So I think if the route is, I don't think I have a friend or family, a member that can fill this role, then maybe we should talk about a neutral third party like a corporate trustee.
Agreed. So One of the things we get asked a lot also is that, I'm appointing a successor trustee, but they're not actually getting anything. I'm not leaving them anything. They're not a beneficiary, so what should I do? How should I tell them? And the answer to that is, you don't have to tell anybody what's in your trust if you don't want to. There is nothing telling you to do that. You can keep it totally as a private document until such time as you pass away. Then those people will at that point find out what's in your trust. But there is nothing compelling you to tell anybody who's getting what when it's in when you've created a trust.
Yeah, and if the concern is, from everything we've talked about, right, it's pretty clear that this is a pretty major role and it requires a lot of hard work. And so I think people don't want this person to feel, oh, I'm not even getting anything and now I have to do all this hard work. But the good news is that the successor trustee has the option to get paid. So you can mandate it within your trust if you'd like, or you can leave it optional. Typically when people pick a family member, they leave it optional. So some people will decide to take the fee and some people won't. We usually encourage, though, our clients, even if they're a child of, the person who passed, that they should take the fee because this was a lot of hard work to get everything done. And the fee is usually standard. It's 1% to 1.5% of, the assets that were within the trust. So if it's a smaller trust, right, it's a smaller fee, bigger trust, bigger fee, because, of course, the complexity level goes up and down depending on that. So they're not going to be not getting anything from your state and also working for free, so you don't have to worry about that.
And finally, the other question that we get asked a lot is, how do I know that my successor trustee is actually going to do what they're supposed to do? Like, what if they do something they're not supposed to? And I think it's a common misconception that because the trust is not under the purview of a probate court and there isn't a judge looking at everything like there would be if you were in probate, that, they can just do whatever they want. And that is completely untrue. A successor trustee has a fiduciary role, and they are governed by the laws in the California probate code, and there are similar probate codes in every state, which mandate that they do certain things in a certain way by a certain time. There are timelines involved, and there are duties that they have to the beneficiaries, and they have to act in the best interest of the beneficiaries at all times. So they are still governed by law. It's not the Wild West, and there are controls on what they can do.
Yeah, so as Somita said, they're a fiduciary, so they have fiduciary duties. So not to give an exhaustive list, but just a couple so that you guys have an idea of what we're talking about. They have a duty of loyalty. So that means that they have to abide by the terms of that trust and do whatever is required of them. So whatever terms are laid out, whatever is supposed to happen, that's what they're supposed to do. They have a duty against self-dealing. So that means they can't take some of these assets. Let's say there's a home. They can't go take that asset and sell it to, their friend or their company or their whatever. That's self-dealing. So they're not allowed to do that. So there are a lot of checks and balances that are built in that prevent this person from doing anything, untoward or fishy with the assets or with the money. So there are, oversight as to what is happening.
Yes.
Okay, so guys. So I see we're getting toward 1:30. So I don't. Tell me how you like to. What do you want to?
Yeah, that was our last thing.
Okay.
Our last thing. This F is for finally you can celebrate. You're done. So
yeah.
You're right on time.
Perfect.
Yep.
Are there any questions from anyone that's online? If so, just drop anything in your chat box. What happens, while I'm waiting, what happens if a family member who is, or a friend or whoever is a trustee and they're living in another state, or we see frequently, especially with the younger millennials, they're popping around for jobs and what have you, kind of all over the place. What's the best way to handle something like that?
Yeah, so that's a good question. We definitely have quite a few successor trustees that don't live in the same state as where the administration is occurring. And so thankfully technology has made this process a lot smoother. So a lot of things can be done, virtually. So we can scan and email and do everything that way. There's a few instances where they may need to be present, in terms of maybe meeting with a realtor or something like that. So we have a current client that lives in back east, and the trust is being administered here. So he's basically only had to come out twice to get everything wrapped up. Everything else was able to be done over the phone or via email or Skype or what have you.
Oh, perfect,
yes.
Perfect. Perfect. You guys, this was great. Super easy for us to understand and some really great points to take into account as all of us talk with our families about how to find the perfect trustee. I can't remember if you guys said this or not, and people can choose, they can change their trustees too, correct? So if they're not happy, right,
yep.
they can bump around and get another one.
Yes.
And there's a question: is there a statutory rate to get, or per regulations, that in terms of payment for a trustee?
So yeah, that's typically the 1% of the trust assets, and so that's the same for if you pick like an individual, a family member, or a friend, or if it's a corporate trustee.
Great. Perfect. Okay. Thank you all so much. It's like perfect. It's 1:30. Perfect timing. You guys are awesome. As everyone knows, we're going to send this out on a replay. Feel free to share with your friends and your family. It's probably a really great way to start a conversation with those folks that you need to have those conversations with, whether it be your spouse, your grandparents, your parents, or even your siblings. So you can just say, hey, I listened to this great webinar on picking a trustee. We should have that conversation.
Yes.
Right? I'm going to share this with you, and then we're going to go have a drink. So,
yeah, there you go. There you go. Yeah.
So thank you all for tuning in. Look for the replay. We really appreciate it. Thank you, Somita. Thank you, Zakiya.
Thank you so much.
Bye-bye.
Bye-bye.